Please.
This is Lordship. I beg to mention item number 9. May I adjourn this matter for the week, Lordship.
Item
Item number 9.
Okay.
Master Bless.
Both sides are president or prayer made by council, learned council of the petition. List after 2 weeks.
May I please also. First, I beg to mention item number 10. Also, in this matter, we have filed an affidavit today. Also, can you bring it on record?
You want to call it?
Okay.
Maybe that's all. I beg to mention item number 13, Lordship. Adjourn for the day, Lord.
Okay.
Oblas.
Same order.
May I please, my Lord? My Lord, I beg to mention item number 12, my Lord. Matter may adjourn, my Lord. So 1 week.
Okay.
Oblas.
Daily list item 1 for admission.
That's a very short point involved.
May I pray, Your Lordship? I am appearing on behalf of the caveator, Your Lordship. The conducting council is on bereavement, Your Lordship. He went to his hometown and returning back, Your Lordship. So may be fixed on next week, any date, Your Lordship.
In this case, we are just issuing a notice because there can't be any interim relief.
Your Lordship may issue notice and it's a very short point involved. Your Lordship may make an observation that an endeavor will be made to dispose of at the admissions.
We are not saying that.
Very, very short point. The only point involved is under
At
rule
times, no, not that. At times we don't know whether we can.
20.
Follow our order.
I'll leave it to you. I'll leave it to you.
Okay. Mr. I. Chaudhary, Learned Senior Counsel, assisted by Mr. ABT Hawk, Learned Counsel for the appellant. Also heard Mr. S.S. Roy, Learned Standing Counsel for the, Mr. G. Bodle, Learned Standing Counsel for the Corporation Department, appearing for respondent number
1 to 4 years.
1 to 4. Next, at the outset, Mr.
R. A. Mazumdar.
R.
A. Mazumdar.
A. Mazumdar, Learned Counsel for the
Caveator.
his respondent number. All the private respondents.
All the private.
For the private respondents of the caveator, raised for an adjournment as the council, Learned Counsel holding the brief is in bereavement. Next one. Having noted that the appellant has assailed the judgment and order dated 12/8/2024, passed by the Honorable Single Judge in WPC 3499 of 2023. And taking note of the fact that the Learned Counsel of the Cavita is in bereavement, the court is inclined to issue under notice returnable on next week,
Any date.
returnable on
Can it be 13th month?
13th.
13 is both cases.
13th is not a matter fixed. 21,
In that case, let it be 22 month. 19th and 20th, I'm required to be in Itanagar.
Acha. 19 and 20.
21st, I don't know whether I'll reach. If I get stuck, let it be on 22nd.
22, 11, 20, 24. You should notice, including notice on the prayer for interim relief. Returnable on 20, you said 22, 11, 20,
22.
24. List it, okay.
Oblige.
Oblige.
Give it discharged. But the Learned Counsel to the Cavita is discharged. And Cavita shall be heard in the connected writ appeal.
Supply list item 16 upgraded for hearing.
So they was to address us. Oh, yeah, yes. Oh, you're there. He's coming.
Yes, coming.
One document I have got, my lord, that the investigating agency, my lord, they issued one notice, my lord, but not by the court. That's it. Showing him as an informant. Two names, my lord, Narendra Doimari. That Musalpur informant, my lord. And number two, my lord.
দুইজনকে দিছিলে
Oh, I'm sorry, Lordship, I could not follow him. Lordship, I was basically on the court of inquiry, by which I tried to impress upon your Lordship. At that point of time, Lordship, there was no silver colored sumo car there. And the car in which the officer was traveling was beyond that place.
Somewhere we found on that day that it was not a silver color sumo, it was a silver color
Sumo Grande.
granite.
That's a red color
Cruiser.
sumo grande. There's
There is
a,
a silver color
Cruiser.
there's a silver
Cruiser.
color cruiser. There's a silver color cruiser. Yes. But there is nothing in the court of inquiry to show that the silver colored cruiser had gone out. There was one car which has gone out, and this particular officer was there. And the driver had vouched in favor of the officer. The driver was there. And I was taking your lordship to witness number 4. Which was a driver. And on perusal of the deposition of the witness number 4, lordship, it transpires that at that relevant point of time, this particular officer and the vehicle were not in that place, and they had not even changed their clothes. Lordship had raised a query regarding the transfer of the ammunition. The transfer of the ammunition was at a later point of time, on that day itself, at a later point of time. And why the officer had gone there to drop the ammunition, that is very much there in the deposition of the officer, in the cross-examination of the officer himself. He says that there was no other officer present. Therefore, he was entrusted to do that work, lordship. And the conclusions which has been arrived at in the judicial inquiry, lordship, that is based upon the witness, basically on the witness of only Rajkumar Rava. Now, that is a judicial inquiry. I cannot say anything on that. But a point has arisen, a query has arisen from your lordship, whether that would be an inquiry as prescribed under the provisions of the CRPC. Of course, lordship, that is not that. But your lordship will examine. We are in a writ proceeding. We are in a writ proceeding. The powers are wide. And an inquiry has been directed to be made by this honorable court, a judicial inquiry. And once an inquiry report has been submitted, it has some sanctity in it. It may not be as per the procedure, because a writ court is not strictly proceeding on the basis of the CRPC or the rules of procedure, the procedural courts. But yes, if
No, but incidentally,
Yeah.
incidentally, just as a passing remark, I'm saying, in one of the cases, I've held in one of the matters in single bench that the proceedings in a writ petition is akin to the
It has the
other
spirit of the
proceedings-
CPC.
other proceedings, and this statements given on the affidavit becomes an evidence.
That's, yes.
So that is an interpretation done by me saying because that to bring the sanctity to the proceedings and also taking that as something which is sacrosanct pleading before the court, and therefore the court would have otherwise power to also hold that the pleading is not in conformity with the rules, can
Yes.
be read to be a contumacious or even to mislead the court, or with the idea that section 195 and 340 would be still available to the court. Once it is a pleading which is false.
Lordship. That is correct, Lordship. That is correct. That nobody can dispute, Lordship. But here, Lordship, Lordship has indicated that maybe Lordship would like to have an inquiry through another specialized agency. I would definitely not object to any further inquiry if the perpetrators of the crime can be identified by that inquiry, then the liability can be fastened, or the whatever Lordship penalty has to be imposed under law, that can be done.
And there's another query, which is supplemental to what you are saying. You see, with the passage of time, 2012, and now we are in 2024, why the principles of public law remedy cannot be invoked to grant compensation?
That is what, Lordship. In fact, I have dealt with a few cases in this line, wherein Lordship, when this judicial inquiry report, it has come to a conclusion that somebody has been killed, and the liability, if not has been fixed on the individual, in any individual, it has been on the state. It is on the state. And the best way not to compensate that is through compensation. Because now it would be too late in the day to again dig out, because the evidences will be gone by now. Mostly. If it cannot be, if the perpetrators cannot be identified, Lordship, the burden is on the state. And Lordship, there are enough decisions. In fact, 2-3 cases I have appeared where the Honorable Court has levied compensation. But that would vary from case to case. Control services. Union of India Control Services. Very excellent. After the technology discuss completed that. Controversy. KOLT. মোটাটা ভালো করবে। Uh, in one of the cases, if I may point out, Lordship, I was a part of it, wherein Lordship, the public law remedy and so far as giving of compensation and all the case laws have been decided. That was a case decided on 25/3/22, reported in 2022 3 GLT, page 187.
Controversy.
Hmm?
Controversy.
The law 2022 3 GLT 187. It's Conto Varisa versus Union of India and others. Conto Varisa. It's a division bench judgment, Lordship, and the law has been discussed very elaborately. In this case, Lordship, the deceased, it was not found that the deceased had any links with the underground outfits. However, they were killed in custody. Our contention in this particular case was that when they tried to flee, then they were shot upon, and thereafter they have expired. But on Lordship, examination of the witnesses and the medical documents, the court has come to a finding no, that they were shot at a point blank range. And therefore the court had awarded compensation of 20 lakhs each. While there have been other cases where I have also appeared subsequent to this, like Bohagi Chutia versus Union of India, and there was Ratanjit Narjari versus Union of India, where we were able to make out that the deceased were part of some underground outfits. Therefore, the compensation was less. But in this particular case, Lordship, after discussing all the previous laws of the Supreme Court as well as of our High Court, since the court has come to a finding that no, they were not involved in any underground activities, and the medical evidences suggested otherwise, then the court has granted this compensation on the public law argument.
But but the Panbari, there are two cases, blood. One is Mosalpur PS case, where the FR was submitted, blood. As because the facts of the case is concerned, blood. The FR number 2 of 2020, which was dated 31/1/2020, it was accepted on 16/3/2023, blood. And blood, I have also seen a communication from the SP that the other case, which was Panbari PS case number 4 of 2015, it was earlier Bizni PS case number 350 of 2012 under section 302 of 302 and 201 of IPC. It was the FR number 40 of 31/12/2016 was submitted as true but not clue, but no clue. So there are two FIRs and there are two FRs. FR number 2 is in 2/2020 is in Mosalpur PS case number 91 of 2012. And FR number 40 dated 31/12/2016 is in respect of Panbari PS case number 4 of 2015 under section 302/201 IPC. It was registered as Bizni PS, subsequently it was re-registered as Panbari PS. This this has been referred. I'm referring to this because on the other day, I have noted a query that two cases are amalgamated and the one informant was heard. And Lordship has directed the learned court below to send the record of both the cases below. Possibly it is available if they are. Yes.
So there are two efforts to have been accepted. No? Okay. No, the issue as regard acceptance of the FR Miller, on that issue, no?
Yes.
So the order dated 16/3/2023 as regard acceptance of the FR is in respect of Mosalpur PS.
No, but we still don't get it. You see,
Malo,
these are two cases.
two cases.
One is Musalpur PS case 91 of 2012.
Malo,
The other is Panbari PS case number 4 of 2015.
4 of 15.
Yes. Now,
Yes.
this Panbari PS
Malo,
was originally registered in Bijni
business,
as
yes, Malo,
350 of 2012.
12. Malo.
Now, the amalgamation order is ten one 2013. Right?
Twenty-three.
Hmm?
Order, my lord. That was order of transfer, my lord, possibly. Maybe. But transfer. In fact, FR has been submitted in Panbari PS in 2016. No?
No. Yes,
Panbari
what I'm-
one, my lord, that was a different person, my lord. It was that ashes were found, my lord. So that one local person saw it, my lord. He lost that FR, my lord.
No, that's okay.
Yes, my lord.
But there was an amalgamation.
Yes, sir.
Amalgamation order is 10-1-13.
That was the transfer order. So, yes, my lord. That can be scheduled to be amended.
Date is correct, 10-1-13.
Yeah, that was the day. It was transferred. So it was tagged together, my lord.
They were tagged together or amalgamated?
Amalgamated as per their own affidavit.
So it is amalgamated.
Yes, yes. ma'am.
So once there is an amalgamation, the case number which is originally registered would amalgamate. Will there be two cases still alive?
But this is my information, my lord.
No, we are not questioning it.
Plus,
We're trying to understand.
But page number 25. There is a petition, there was a petition, my lord, for transfer of one Tamulpur PS case number to Mosalpur. And page number 27 is transfer of Tamulpur PS case number to Mosalpur, my lord, for further investigation. Page number 27 of the read petition, my lord.
Yes.
if my lord kindly takes up page number 33.
Yes.
Page number 33, well, this is an FIR, this was registered as Busy PS 350 of 2012. Yes, my lord, under 302 201 IPC.
Yes.
So this was possibly not amalgamated, my lord.
No, this,
This Busy PS subsequently became Panbari, my lord.
Bijli case is Panbari.
Yes, Busy PS case, as it was re-registered as Panbari PS 4 of 2015.
So that means Musalpur case
Mosalpur case.
and Panbari are two different, two cases.
Two different cases. Matlab, that Panbari is under 302 1 and 201 IPC, and the Mosalpur is under 364. Sorry, 365 34. And Matlab, the Tamulpur PS case was also under 364 302 34. At page 25, Lordship will get.
Page.
Page 25, it refers, my lord. Subject prior to pass an order for transfer the Tamulpur PS case number 193 of 2012 under section 364 302 34 to Mosalpur PS.
Yes.
So my respectful submission before Lordship is the query posed by your Lordship that two FIRs were amalgamated and one informant was heard, other was not heard, while accepting that may not come in this case. Because there are two cases, two FIRs. And Lordship has indicated in the order on (28).
Now this,
But Lordship, kindly come to order dated 28/2024. Lordship's
just-
order, my lord.
no, just a moment.
Lordship.
This, this Rajkumar Rabha,
Yes, my lord.
he's connected with which case? Musalpur or
He is
Pandari, both.
he is connected with the incident is he's connected with Masalpur. Incident is same, my lord.
91 of 12.
And this P2 Narendra Daimari, he is
Well, in fact, what I find, the informant of the business PS, he is not a petitioner here.
Okay, but this petition number 2, he is associated with which matter? Panbari or Musalpur?
Musalpur.
Musalpur.
The first FIR, my lord, page 14, Lord should find, my lord. Because Rajkumar, he was kidnapped. Thereafter, Narendra Devimari, that is petition number 2, he lost the initial, my lord, FIR. Subsequently, number 2, my lord, that number 3, Jyotish Goswami Mutari, my lord. He
This
is
P3 is
Tamulpur, my lord.
Tamulpur.
Yes, my lord. Which was transferred and subsequently both the cases were amalgamated, my lord.
But the informant was Robin Bosumatari.
Itu তোমার
That
Disney to
yes,
পাটবাড়ি
yes.
হয়েছে এটা।
Yes, yes. At page 35.
Yes.
So, my lord, on the issue of final report, I would like to place reliance on 2 decisions of the Honorable Apex Court. The first is Lordship 2004 SCC 459.
2000 volume 4 SCC.
2000 volume 4 SCC 459.
Yes. What is the name of the parties?
The R Sarla versus
R?
TS Velu. R Sarala.
Spelling?
R dot SARALA Sarala.
Huh.
R Sarla versus TS Velu.
TS.
T
T.
T T
Tripura.
S yes, TS Velu VELU Velu.
VLU.
V मतलब V
V victory. VELU.
LU Velu
Yes.
and others. But here, my lord, Lordship may kindly come
That is-
to paragraph 11. This is on the issue of formation of opinion by the police, whether they will submit the FR or they will charge it. It is the police authority. On the materials available during investigation, it is the police authority. They have the IO has to make up his mind. I'm on that, Lord.
2000 volume 4 SCC 459. Yes, which paragraph?
Para 11, Malad. Para 11 onwards, Malad, I'll take your lordship. It starts. Kindly come to para 11 first, Lord. 11, 12, 14, 15, 16, 17, and 18 are 11. Kindly come to para 11 first, Lord. Lord, there is no material difference regarding general powers of investigation by the police as between the present code and the corresponding provisions contained in chapter 14 of the erstwhile Code of Criminal Procedure 1898. In HN Rishbad versus State of Delhi, a 3-judge bench of this court, after delineating the different steps in investigation as contemplated in the code, has pointed out that the formation of the opinion whether or not there is a case to place the accused on trial should be that of the officer in charge of the police station and none else. The following observations are to be noted in this context. The scheme of the code also shows that while it is permissible for an officer in charge of a police station to depute some subordinate officer to conduct some of these steps in the investigation, the responsibility of every one of these steps is that of the person in the situation of the officer in charge of the police station, it having been clearly provided in section 168 that when a subordinate officer makes an investigation, he should report the result to the officer in charge of the police station. It is also clear that the final step in the investigation is the formation of opinion as to whether or not there is a case to place the accused on trial is to be that of the officer in charge of the police station. There is no provision permitting delegation thereof, but only a provision entitling superior officer to supervise and or participate under section 551. Well, in this particular case, the Honorable High Court, when the matter came to Honorable High Court has set aside the FR and send it back with a direction that you took the opinion of the public prosecutor and then you submit the final report. So while dealing with that situation, the Honorable Court in paragraph 12 has noted, kindly come to paragraph 12. A public prosecutor is appointed as indicated in section 24 of the code for conducting any prosecution, appeal, or other proceedings in the court. He has also the power to withdraw any case from the prosecution with the consent of the court. He is the officer of the court. Thus, the public prosecutor is to deal with a different field in the administration of justice, and he is not involved in an investigation. It is not the scheme of the code for supporting or sponsoring any combined operation between the investigating officer and the public prosecutor for filing the report in the court. In this context, a reference can be made to the following observations made by the Judicial Committee of the Privy Council in Emperor versus Khwaja Nazir Ahmed. In India, as has been shown, there is a statutory right on the part of the police to investigate the circumstances of an alleged cognizable crime without requiring any authority from the judicial authorities, and it would, as their lordship thinks, be an unfortunate result if it should be held possible to interfere with those statutory rights by an exercise of the inherent jurisdiction of the court. Following the above, a two-judge bench of this court has stated in Abhinandan Jha versus Dinesh Mishra as follows. We have already pointed out that the investigation under the code takes several aspects, the stages ending ultimately with the formation of an opinion by the police as to whether on the material covered and collected, a case is made out to place the accused before the magistrate for trial, and the submission of either a charge sheet or a final report is dependent on the nature of the opinion so formed. The formation of the said opinion by the police, as pointed out earlier, is the final steps in the investigation, and the final step is to be taken only by the police and by no other authority. Paragraph 15. In this context, we may also point out that the investigating officer, though is subject to supervision by his superiors in the rank, is not to take instruction regarding investigation of any particular case, even from the executive government of which he is a subordinate officer. This position, which was well delineated by the celebrated Lord Denning, has since been followed by this court. In R versus Metropolitan Police Commissioner, Lord Denning has said thus: I have no hesitation, however, in holding that, like every constable in the land, he should be, as is, independent of the executive. He is not subject to the orders of the Secretary of the State. I hold it to be the duty of the Commissioner of Police, as it is of every chief constable, to enforce the law of the land. He must take steps so to post his men that crimes may be detected and the honest citizens may go about their affairs in peace. He must decide whether or not suspected persons are to be prosecuted, and if need be, bring the prosecution or see that it is brought. But in all these things, he is not the servant of anyone, save of the law itself. No minister of the crown can tell him that he must and must not keep observation on this place or that he must or must not prosecute this man or that man. Nor can any police authority tell him so. The responsibility of law enforcement lies on him. He is answerable to law and to the law alone. But para 16, Lord. In Binit Narayan versus Union of India, three judge bench of this court, after quoting the above passage, has stated there can hardly be any doubt that the obligation of the police in our constitutional scheme is no less. In State versus Rajkumar Jain, a two-judge bench considered the legality of an order passed by a special judge before whom CBI filed final report in respect of a junior engineer who was pitted against offences under the Prevention of Corruption Act. CBI in the report held that the allegation made against him were unsustainable, but the special judge declined to accept the said report. As in his opinion, CBI should have taken the view of the sanctioning authority. So the special judge directed CBI to conduct further investigation after approaching the sanctioning authority. Though the High Court of Delhi did not interfere with the said direction, this court interfered with it, for which their lordship followed the decision in Abhinandan Jha. The bench then observed thus: viewed in that context, CBI was under no obligation to place the materials collected during investigation before the sanctioning authority. When they found that no case was made out against the respondent, to put it differently, if CBI had found on investigation that a prima facie case was made out against the respondent to place him on trial and accordingly prepared a charge sheet against him, then only the question of obtaining sanction of the authority under Section 6(1) of the Act would have arisen. For without that, the court would not be competent to take cognizance of the charge sheet. It must therefore be said that both the special judge and the High Court were patently wrong in observing that CBI was required to obtain sanction from the prosecuting authority before approaching the court for accepting the report under Section 173(2) of CRPC for disregard of the respondent. It is worthy to notice that even when the law requires that prosecution could be commenced only with the sanction of the authority concerned, this court took the stand that such sanctioning authority is not a consultee of the investigating officer to form his opinion regarding the final shape of investigation. The position in the present case is even much lighter, and hence the investigation officer cannot be directed to be influenced by the opinion of the public prosecutor. But kindly come to the next case, Malad. I have given the citation. Malad, this is 2004 Criminal Law Journal 2648. 2004 Criminal Law Journal 2648.
2648. Name of the parties?
Name of the party Harinder Pal Singh versus State of Punjab. Harinder Pal Singh. This is before the Punjab and Haryana High Court, but some of the observations the court has placed reliance on the decision of the Honorable Apex Court on the Abhinandan Jha case.
You find Criminal Journal here. Criminal Journal is not there.
But kindly take note of paragraph 10. I'll give print out. In this similar line, the scheme of the act, the CRPC has been discussed and ultimately said that it is the police authority. He has the authority. He is competent to form the final opinion. I'm on that. He has also relied on this R. Sarla versus T.S. Velu and paragraph 11, 12, 13 and 14. The legal position has been discussed. 11, 12, 13 and 14. So I am placing the reliance on these two decisions.
This paragraph numbers?
Paragraph number 10, 11, 12 and 12, 13 and 14. 10 to 14. I'm sorry, I did not take the printout, but in the same line as I have already read the R. Sarla case. In fact, this has this reliance. The scheme of the act, the CRPC has been discussed. Malat, may I read?
You're already halfway through it.
Lordship. But this is one limb of my submission before your lordship. But the as regard the formation of the opinion by the investigating authority, and the second is, my lord, the second limb of my submission would be, my lord, the decision which is already placed before your lordship, my lord, I would like to refer to that only, my lord. In the case of Nitu Kumar Nagesh, 2020 16 SCC 777, my lord, 777.
Please give it again.
2020 16 SCC 777. Nitu Kumar Nagesh, NWTU, Nitu Kumar Nagesh, NAGAICH, versus State of Rajasthan. This has been already placed on the other day, before your lordship, Lord.
Yes.
Although-
Paragraphs.
Malad, para 10 to 18, Malad, although the investigating authority has all the power to make investigation and form his opinion, Malad, here the honorable court has, Malad, discussed this scope when, after submission of the FR final report, court can direct for reinvestigation. From para 10, Malad, normally, when an investigation has been concluded and police report submitted under section 173(2) of the code, it is only further investigation that can be ordered under section 173(8) of the code. But where the constitutional code is satisfied, I'm on that, my lord. Where the constitutional code is satisfied that the investigation has not been conducted in a proper and objective manner, as observed in Kashmiri Devi versus Delhi administration, fresh investigation with the help of an independent agency can be considered to secure the ends of justice so that the truth is revealed. The power may also be exercised if the court comes to the conclusion that the investigation has been done in a manner to help someone to escape the clutches of the law. In such exceptional circumstances, the court may, in order to prevent miscarriage of criminal justice, direct de novo investigation as observed in Babu Bhai versus State of Gujarat. A fair investigation is as much a part of the constitutional right guaranteed under Article 21 of the Constitution as a fair trial, without which the trial will naturally not be fair. The observation in this context of Babu Bhai are considered relevant at para 45 are as follows. 45, not only fair trial but fair investigation is also part of constitutional rights guaranteed under Article 20 and 21 of the Constitution of India. Therefore, investigation must be fair, transparent, and judicious, as it is the minimum requirement of rule of law. The investigating agency cannot be permitted to conduct an investigation in a tainted and biased manner. So these are the exceptional circumstances, if it is there in the report, where non-interference of the court would ultimately result in failure of justice. The court must interfere in such a situation. It may be in the interest of justice that independent agency chosen by the High Court makes a fresh investigation. But in this particular case, my lord, the boy was found dead lying in the train line. Police has submitted the FR final report that he has committed suicide, but there was no blood, the blood stains in that particular area where he was found, but bloods were there in his clothes. So there was some doubt, and court has observed that the investigation was done in a lackadaisical manner, not bona fide. When those are found, Malad, under that circumstances, honorable court has said that FR reinvestigation, constitutional court can direct reinvestigation by an independent agency, and it was directed in here, Malad. So, Malad, paragraph 11 to 18, Malad, all these things, in the similar line, the other decisions of the honorable apex court have been discussed, and the final principle enunciated by this honorable court, Malad, the law laid down by the honorable apex court is that if there is no bona fide, if there is doubt, if the investigation is not done properly and to save somebody else, Malad, then the constitutional court is not powerless, and court can direct reinvestigation by an independent agency or by the police, whatever it is, Malad. So, Malad, with both this, Malad, my respectful submission is, Malad, in the records which is given to me, Malad, I have seen that I'm just referring to the report which is placed on 2/7/2024 before Lordship, Malad, the letter given by SP Baksa, Malad. There they have indicated that FR has been submitted, and if Lordship kindly comes to pursuant to the Lordship's direction of 28/20/2024, we have obtained some instruction and we have placed it. Our letter is 2/7/2024. Here, Malad, I would take your Lordship to serial numbers. This is a form, Malad, submission of final form. Kindly come to serial number 17, Malad, at internal page 5, Lordship will find. Final form report. It starts, Malad, and kindly come to internal page 5, serial number 17. Malad, what they have indicated, facts disclosed during investigation. Facts disclosed during investigation. Separate sheet to be attached. They have attached separate sheet. So this is not with us, Malad. Possibly this has come to your Lordship, Malad. Your Lordship has called for that record from the honorable court. Serial number 17, Malad. First, they have said brief fact background of the case, separate sheet to be attached. They have attached.
Yes, facts disclosed in the separate sheet.
And facts disclosed during investigation, separate sheets to be attached. They have attached separate sheet.
Yes. The case written in FR as a case is true, but case is true under section so and so, but no clue
Yes, yes.
of accused person.
But the details possibly they have given in the separate sheet. So, Lordship, my submission will be, Malad, and the order dated 20th of August, Malad, it indicates that Lordship has called for that record from the court below, Malad. Para number 6 of that order. Lordship's order dated 20th of August 2024, paragraph 6.
No, there's no, you see, you don't have a copy.
Well, which one? The
This
22/7/24.
24.
I have,
Then the last page of that
Lordship.
diary ends. After that, there are three other pages.
Lordship.
Fourth page from the last.
Brief fact background of the case.
Yeah, after that. Facts disclosed during investigation.
That. Possibly it is not with Suranto Protibedan. That is
No,
the
no.
last page.
You were this brief facts background of the case. You have got that?
Brief fact background I have.
That is nowadays page 27 in the top round seal.
Facts disclosed during
Next
investigation.
page to that.
But they have said that it is in separate sheet.
This is separate sheet.
Maybe in the record, that is why I'm recording.
No, because this is, you see, when the charge sheet is, this final report is submitted, it's in a printed form. These two are separate papers. 2 pages. One is that brief facts background of the case.
Correct.
Immediately next page.
Next page. Yes. Facts disclosed during investigation.
This is the only one.
Case written in FR as the case is true.
Yes. That is the only.
But ultimately they have to see during investigation what they have done, that is why possibly the honorable court has called for the record from the court billable.
No, we had only called for the scanned copies, and this is the only thing which has come.
But to whom they have whose statement they have recorded, what they have done, the entire thing has to come. The Lordship has to ultimately take a decision after perusal of that, whether they have done the investigation bona fide or not.
You are referring to order of which date?
20th of August 2024.
No, we had only called for the scanned copy of the order sheet.
I have some reservation that this is the entire investigation thing, because the detailed investigation statement of the witnesses examined during investigation, everything has to be there. That is why I thought that they have given separate sheets in the. Of course, there is some important. Well, if Lordship permits, I'll read the last paragraph of this letter. It starts with Suranto Protibedan 2 of 2020. The second page, Lord. Mukodamatur Todonto কালিত মোকৰ্দমাৰ ঘটনাস্থান পৰিদৰ্শন, গোচৰীয়াৰ লগতে সাক্ষীবাদীৰ সোধ-পোছ কৰাৰ লগতে জবানবন্দী লিপিবদ্ধ কৰা হয়। লগতে পঞ্জীৰ লগত গাঁঠি ৰখা হয়। প্ৰকাশ থাকে যে যোৱা 23/12/2012 গোচৰীয়া জ্যোতিষ বসুমতাৰী তামোলপুৰ থানাত একেদিনাই তাৰ পুত্ৰ ৰাজীৱ বসুমতাৰীৰ ওপৰত উল্লেখ কৰা অপহৰণকাৰীৰ লগত একেলগে অপহৰণ কৰা আৰু তাৰ সন্তান ৰাজীৱ বসুমতাৰীৰ মৃতদেহত তামোলপুৰ থানাত অন্তৰ্গত ডংপাৰ্কত উদ্ধাৰ হোৱা মতে এজাহাৰ তামোলপুৰ থানাত দাখিল কৰাত মোকৰ্দমা ৰুজু কৰি ঘটনা একে হোৱা বাবে এই মোকৰ্দমাৰ লগত সংলগ্ন কৰা হয়। তদন্তকালীন পদকীয়াৰ সংসূত্ৰ উলিয়াবৰ বাবে জোৰ তদন্ত কৰা হয়। লগতে মৃতকৰ পোষ্টমৰ্টম ৰিপৰ্ট, PM ৰিপৰ্ট, FSL ৰিপৰ্ট সংগ্ৰহ কৰা হয়। These records are there with the investigation.
But then
Mo-
this comes to the
মোকৰ্দমাটোৰ তদন্ত
AK-47 আৰু 9mm pistol. Come after that, read after
Yes,
that.
yes. মোকৰ্দমাটোৰ তদন্তকালীনত এজন সন্দেহী ব্যক্তি শ্ৰী মহেন্দ্ৰ দ্ৰেউৰীক গ্ৰেপ্তাৰ ক্ৰমে মহামান্য আদালতত প্ৰেৰণ কৰা হয়। তদন্তকালত ঘটনাৰ জড়িত টাটা চুমুৰ বিৰুদ্ধে তদন্ত কৰাৰ লগতে ড্ৰাইভাৰৰ মালিক ক্ৰমে শ্ৰী বাবুল বড়ো আৰু শ্ৰী মনোজ তালুকদাৰক সোধ-পোছ কৰা হয় আৰু DC অফিচৰ নজিৰ ব্ৰাঞ্চৰ লগত আলোচনা কৰা হয় যদিও উক্ত ঘটনাত ব্যৱহৃত টাটা চুমুৰ কোনো সন্ধান পোৱা নগ'ল। ঘটনাত জড়িত থকাৰ সন্দেহত 12th so-and-so ৰেজিমেণ্টৰ লগত যোগাযোগ কৰা হয় যদিও তেওঁলোকৰ কোনো সঁহাৰি পোৱা নগ'ল। তদন্তকালত অপহৃত ৰাজীৱ বসুমতাৰীৰ মৃত্যু that was due to asphyxia result of antemortem homicidal throttling. All the injuries were antemortem caused by blunt force impact. Till here. So my submission is that they have investigation and they have investigated and taken
In the first page,
yes, my lord.
in the first page, this last 5 lines,
Logic.
uh,
ঘটনাৰ চমু বিৱৰণী এই যে যোৱা 22/12/2012 তাৰিখে
like last 6 lines.
লজিক হঠাৎ এখন ৰূপালী ৰঙৰ ভেহিকল কালাৰত অহা 4-5জন মান অচিনাক্ত মানুহে উক্ত দোকানৰ সন্মুখত গাড়ীখন ৰাখি গোচৰীয়াৰ ল'ৰাৰ লগত পাণ দোকানী ৰাজকুমাৰ ৰাভাক জোৰ জবৰদস্তি গাড়ীত ভৰাই মচলপুৰৰ ফালে লৈ যায়। দুৰ্বৃত্তৰ লগত AK-47 আৰু 9mm পিষ্টল লগতে চিভিল ড্ৰেছত আহিছিল আৰু মুখত কাপোৰ মেৰিয়াই লোৱাৰ বাবে চিনাক্ত কৰিব পৰা নগ'ল। মতে জনোৱাত মোকৰ্দমা ৰুজু কৰি ভাৰতীয় দণ্ডবিধি আইনৰ 365/34 ৰেড উইথ Section 27 আৰ্মছত ৰুজু কৰি তদন্ত কৰা হয়। But my respectful submission is that during investigation they have examined many witnesses and done and obtained some reports and all these things. So everything has been submitted while submitting the FR before the honorable court, and that has been perused and accepted. That is what my indication is, my submission is. So if it is available, the decisions which I have placed, the lordship can after perusal of that, can form a can take a decision whether it was done properly or not. Only on the submission made by the petitioners, that investigation was not done properly and it was accepted, a decision may not be taken. That is what my respectable submission with your lordship.
This
Order sheet বিলাকত আছে নেকি? All records বিলাক চাইছো। থাকিব পাৰে ন? কিন্তু order sheet বিলাকত কি কি দিছে, কি কি দিয়া নাই ৰাখিব লাগে। না, FR না, FR সব নিদিব নেকি? All investigation record বিলাক নিদিব নেকি? দিব লাগিব, তো সেইবিলাক থাকিব তো। কিন্তু পেৰেজ কৰি পেলাই order নিলিখিব।
This,
But section 173 CRPC is very clear.
no, this final report submitted,
Lordship.
please come to internal page 5.
Yes, Lord.
The list of documents
My lord.
is 2 copies of sketch map,
My lord.
1 copy of report of victim,
My lord.
1 copy of official report,
PM report or one
One
copy of
copy
PM
of-
report of victim.
FR
Name, please,
notice
so and
to
so.
complainant,
Lordship.
correct?
Lordship.
1 copy of PM report of the victim, 1 copy of official report, 1 copy of FR notice to the complainant. And separate sheet for so and so.
Lordship.
This case diary does not appear to have been submitted.
But
The
there may be some indication in the order sheets of the court below. Lord.
the order sheets are available.
Lordship. Probably will you want to read the sheet? Probably will you. So it will be 8 to 3,000. Range in down for you are satisfied that if we belong.
Okay, CD was submitted,
Case diary was submitted.
19/123.
This normally this has to be me. Yes. Mail of the কোন তো মেলো কোন তো মেলো কি বলছে কোন তো মেলো দিছে কোন তো মেলো বুঝতে না কেমন কেটে দিছা বলে মানে কেতিয়া এটা আমরা নেই Chamber 9. No materials. No person. যদি বনাফাইডে না হয় তেতিয়া ঠিক আছে পিছত দিলে
The concept of primary case case. Yes.
Very also this has been.
Mr. Nath, this,
Follow.
we got the records of Musalpur.
Malad.
The Panbari PS you are still to receive.
That is not I have seen Malad in the order it is not
It's not there.
it is not reflected. That has to be because there are two efforts.
Panbari PS case will come from where, Mr. Chaudhary? It is, who would be the custodian of the records?
Sirang. It is from Sirang possibly. This is Sirang. The Sirang.
Because Panbari is 360,
Panbari
365, 302.
302-201.
So therefore, competent authority would be the district judge.
Session judge. Look. No.
But in this case, this Musalpur PS case,
Malad.
that is also 364-302. Read with 25(1)(a) of the Arms Act.
Gotcha.
But the final report was accepted by the Chief Judicial Magistrate.
But it is always the FR or charge sheet. It is submitted before the judicial magistrate CJM court. If he Malad accepts it, then after committal he used to send it to the session judge.
Yes.
Otherwise, police has to submit it before the CJM.
Okay, you're right. Then it would be Chief Judicial Magistrate.
Yes.
Sirang.
CJM. Malad, it is on. Malad, just add one sufficient, Malad, because the magistrate has the power to accept, or he can also under 178 he can direct for reinvestigation. He has the power. Here is a case where the magistrate has accepted. He cannot be disbelieved like this. The constitutional court has the power after perusal of the records, Malad, if an opinion is formed.
That's. Say it.
Lordship has to record Lordship's satisfaction or dissatisfaction. That much is the. And my lord, it is also possibly placed because Lordship in the order date 20th of August has also directed us to see whether one Nikasi outpost and Mosalpur outpost, they have stated, petitioner has stated that they have also filed some FIR.
There is no record.
No, there is no record. That it is already we have informed about.
We have that communication.
Yes. No. Nikasi are very nice. নিকাশি উক্তি আৰু মেছলপুৰত মানে 24-25 তাৰিখত নাই দিয়া 24 তাৰিখত নাই দিয়া
That is here.
কৈছা আহিছে তেওঁ ৰখি কৰিছে এই কোৱা বহি
Mr. E. Chaudhary, then counsel for the petitioners is present. And so the submissions of Mr. R.K.D. Chaudhary and learned DSGI is concluded. Next. The submissions of Mr. D. Nath, learned senior government advocate for the state remains inconclusive. Next, in course of his submissions, the learned senior government advocate has submitted that it would be appropriate for the court to peruse the case diary relating to Mosalpur PS case number 91 of 2012. Which is lying with the court of the learned chief judicial magistrate, Baksa. As reveals from the scan copy of the order dated 19/1/2023. Passed by the Honorable Chief Judicial Magistrate, Baksa, Mosalpur. In connection with Mosalpur PS case number 91 of 2012. Next, it is further submitted that the scanned copy of the order sheet as well as the case diary of Tamulpur PS case, no, sorry, Panbari PS case number 4 of 2015. We also call for from the Court of Learned Chief Judicial Magistrate Chirang, which place?
Srirang Kajalgaon.
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 Chirang Kajalgaon. Next plan, according to the registry shall send a requisition to the court of the following requisitions. Number one, the court of learned chief judicial magistrate. Buxa. Nishalpur. For the scan copy of the case diary of Musalpur PS case number 91 of 2012. For which the said learned court may refer to the order dated 19/1/2023. Next, number two, the scan copy of the order sheet as well as scan copy of the case diary of Tamilpur PS case, Panbari PS case number 4 of 2015. For which requisition will be sent to the Court of Learned Chief Judicial Magistrate, Chirang, Kajalgaon. Next paragraph, the requisition will be sent by email with liberty to the said learned court to send the scan copies that we got through email for being placed before this court. Next paragraph. List on 14/11/2024. Before that, you also write. You also put it on record that the senior government advocate for the state has produced a copy of forwarding letter dated 17/9/2024. Received from the Superintendent of Police, Buxa Mushalpur. So the same is kept as part of the record. This lists the matters, parted matter also and so on. Will again come as a parted matter.
Lordship, on 14/11.
Take a break and come back.
May I please your lordship? My lord, on the earlier day, my lord, I have submitted my argument in written, my lord. Also, I have furnished certain decisions, my lord, which I have relied, my lord. However, may I submit one thing, my lord? I was selected as distributorship of LPG gas cylinder, my lord. And my selection was challenged by the respondent number 1 hearing. And that was interfered with by the Honorable Single Judge, my lord. Lordships, Honorable Single Judge order, my lord, page 93, my lord.
Page 90.
93, relevant
Three.
page, my lord, 98 of my memo of appeal, my lord. One of the criteria, my lord, that for establishment of showroom, my lord, the applicant must have own land, my lord, or a land by deed of lease. Herein, my lord, the applicant does not have his own land, but the land he got by way of lease, my lord. And finding of the learned single judge, my lord, that the lessor cannot execute the sale deed as he is not the absolute owner, but a co-owner. Now issue is very limited, my lord, whether co-owner can execute lease deed to the extent of his share, my lord. This is the core issue, my lord.
In the writ petition, you were respondent number 5.
Yes, my lord.
You were
I am
respondent number
responding.
5. Your LPG dealership was assailed,
Yes, my lord.
correct? Okay. Okay.
Now, my lord, stand of the authority, my lord. Lordships will find at page number 202 and 3. That was the stand taken by the BPCL authority, my lord. Para 7 onwards, my lord. May I read, my lord?
Please tell me, as per the guidelines,
My lord.
please come to paragraph 9 of the judgment. This clause 6.1 requires that the applicant should own a suitable shop.
Yes, my lord.
This finding is correct?
And 96.
That the guidelines requires he should own a suitable shop.
Now, the word own defines, my lord, in the brochure, my lord, guideline, my lord.
That is paragraph 10.
Yes, my
Own means having ownership title of the property or registered lease agreement for minimum 15 years in the name of the applicant family member as defined in multiple distribution norms of eligibility criteria in case of ownership of family members, consent of so and so. Yes. Now, where is your lease agreement?
Page, my lord, 122, my lord.
122.
No, 72. Lease agreement.
Page 72, my lord.
Huh?
Page 72.
72.
Yes.
Same thing, same document.
Yes.
122 and 72 are same.
It is go down.
Yes, same. Really, last page.
Yes. Yes. Yes.
Regarding lease agreement, my lord, I stand taken by the BPSL authority, my lord, page 102 and 3, my lord. Hundred and two, my lord. This was affidavit in opposition filed by them. Para 7.
Where is the Jamamandi of the said land? Page 119. Is it page 119?
Yes.
Yes. Bagiram Deori.
Yes, ma'am.
Bagiram Deori, cell number 6. বাগান অংশ এক কথা সুন্দর এসব মাটি আপনারা নিতেন দেরি বগিরাম দেরি আমার নার্সারি হবে so 1 kata 15 lesser land.
And there are 4 pattadas, my lord, on earth.
Not for Patala, for this part, it is mutated in the name of Leni Deori, Lokiram, Swami Lokiram, Sri Jadav Deori, Bogiram Deori, 60 Deori, 4 people. Including him 5. This is a mutation order of 24/2/2009. Yes, okay.
And my lord, each will get, my lord, more or less 7 less, my lord. And the required land is less than 2 less, my lord. As the required dimension is, my lord, 4 meter into 3.33 feet, my lord. So it is less than 2 lesser. Therefore, my lord, he can exhibit the lease deed, my lord, to the extent of his share, my lord.
Yes.
My lord, my contention is that, my lord, the area of land leased out, my lord, 4 meter into 6 meter. That is within the limit of his share, my lord. So, my lord, section 44 of transfer of property act, my lord, provides that he can transfer his share, my lord, undivided property on the, to the extent of his share, my lord, not more than that. That is my only contention, my lord. Therefore, lease, my lord, is valid, my lord. My lord, now, my lord, may I rely on a decision, my lord? That decision, my lord, I have submitted along with my written argument, my. The first decision, my lord. AR 1950 PEPSU 5, my lord. PEPSU High Court, my lord. Para 3, my lord.
Yes,
May I read, my lord?
yes.
It is an admitted principle of law that if a co-sharer is in exclusive possession of any portion of an undivided holding, not exceeding his own share, it cannot be distributed in his possession until partition. If instead of remaining himself in possession, he transferred this portion of the joint kata, his transferee will also have the same rights and cannot be disposed by the other co-sharers until a final partition between the co-sharers has taken place. Applying this principle to the facts of the present case, the plaintiff cannot succeed in dispossessing the defendant or cannot claim a joint possession with them till the final partition of the whole of the joint kata. Disposition of the transferee cannot be that of a trespasser, but only a co-sharer subject to adjustment at the time of partition.
This is a writ petition of 2016. Correct. This is a writ petition of 2016.
Read petition.
Correct. Writ petition is a writ petition of year 2016, right?
Yes, ma'am.
Now, the order of the Learned Single Judge was passed on 14/5/2018.
18.
In this 2 years' time, did you file any document that the others have other 4 legatees,
Madam.
other 3 legatees?
Yes, ma'am.
You are the 4th one. They have no objection to your lease.
Now, my lord, land is fall under my share only, my lord. That I have placed, my lord, by way of an affidavit, my lord. As directed by this honorable court, my lord. Affidavit filed on,
Where is that?
my lord, 22nd of August 2022, my lord. That additional affidavit may kindly be looked into.
27 August 22.
Yes, ma'am. Not the entire portion of the land, I became the owner, ma'am. I have submitted the copy of Jabamandi, my lord. Affidavit dated 22/8/2022, my lord.
Where was that previous Jamabandi?
Previous Jabamandi, my lord, page 119, my lord. 119. 119, my lord.
There is vernacular, my lord. 118 is
109,
119,
19.
119. That
Yes.
is the vernacular, my lord, and translated probably 118.
That means this document in your additional affidavit,
My lord.
this was not placed before the learned single judge.
No, that is afterward.
Yes, my lord.
It is after institution of the, my lord, writ petition.
No, after institution of the writ petition, but before the judgment were delivered.
No, my lord.
That
Mutation
was
order,
not placed, my lord, before.
No, my lord. In fact, they have not even filed affidavit in before the learned single judge, my lord. They have not even, my lord. And my
no,
lord,
no, but
actually,
otherwise, you see this affidavit, you have a copy of that affidavit, Mr.
My lord.
Monto.
my lord,
Please see that affidavit.
that is in appeal, my lord,
No, we understand,
my lord,
but is this something I would like to show it to you?
my lord.
This Jamabandi, you
My
have a
lord.
copy of that? Please read that
Yes.
Jamabandi.
119.
No, no. There annexure M in the additional affidavit.
H.
Annex है दिया ना
First step. First step.
लेकिन our copy without any annex. My lord,
You've seen that? As per order dated 6/12/2016. So this partition order is of 2016. And this judgment came in 2018. That means it was there, it was available there.
my lord. আমার ধ্যান নাই এইটো কপি কপি দিছে annex এখন দিয়া আমি সার্ভিস কপি এইটো আপনি দিছে পাইনি ঠিক আছে
And what is the civil suit? There is a reference to civil suit. What is that?
That was, my lord, mutually settled, my lord, and it was withdrawn, my lord, as per my instruction.
Where is that?
My lord, that, my lord,
77.
yes.
So it is for right type of investment.
This before this oil company. Did you give a sketch map of the plot of land?
No, in fact, my lord, he falsely presented made before the authority, my lord, on the date of application, my lord. On the date of application, my lord, he said, my lord, he shown a, my lord, your lordship kindly see the tender condition, my lord, has to be fulfilled on the date of, my lord, application. Last date of application. In last date of application, my lord, he showed, my lord, that so and so is the absolute owner. That is a false declaration, my lord, and that day he is not the absolute owner, my lord. If he is not a co-owner, then other co-share has to be given pass certificate, my lord. That was not done, my lord. Your lordship kindly see the clause, my lord. If there is a false information given to the court, my lord, and to the tender, my lord, they can take action, my lord. There is provision also there. So that's why, my lord, your lordship kindly see when lead petition was moved, no affidavit has been filed. Nothing, my lord. They are keep mum, my lord. Now that's why, my lord, the judgment is clearly reflected everything, my lord. Your lordship kindly see their affidavit, my lord, the sale lease agreement, my lord. The person shows that I am the absolute owner. So since absolute owner, there is no question of, my lord, affidavit from the other co-owner. So that's why that statement was wrong, my lord. So that is the case, my lord.
May I submit one thing?
That's why, my lord, learned single judge very elaborately discuss everything, my lord, and that is, in fact, my lord, that one line, my lord, there, page 98, your lordship kindly see. Page 98, my lord. Page 18, my lord. Subsequent mutation in the name of Borgoram Dairy over the plot of land is no consequence. The validity of the tender is to be judged on the date of submission of the tender. And in the instant case, the last date of submission of tender was 31/10/2014, the 13th, my lord. The leaser of the respondent number 5 has not absolute owner of the land in question, my lord, on that particular day. And that affidavit which was submitted by the, my lord, appellant, my lord, was, my lord, absolutely, my lord, incorrect affidavit, my lord. As is, he is the absolute owner, my lord, he done that way.
Absolute owner, my lord, in respect of required dimension, my lord, not the entire land, my lord. That lease implies that, my lord. The absolute owner of a land measuring 4 into 6 meters. Meaning thereby that land is within his share, my lord. That is my submission, my lord.
That's problem.
Mr. Sekian, unfortunately, when you show us the Jamabandi, this is a document we can read. If it is mutated in the name of 4 people, one cannot come and say that he is the absolute owner.
My lord.
You can be you can be a possessor of a particular plot of land. If you are citing section 44,
44, yes, for property.
please read section 44. Third line of section 44 would be more relevant.
Where one of 2 or more owners of immovable property legally competent in that they have transferred his share of such property or any interest
No,
therein.
see, the first line.
Well,
What is the first word? If. How does it start? If.
well, Section 44, my lord, transfer by one co-owner, where one of 2 or more.
Where 2 or more co-owner.
Yes, ma'am.
So question of absolute owner is not there. 2 or more owner.
Yes, sir.
Now please read. I'm more interested in third line onwards.
The transferee acquires as to such share of interest and so far as is necessary to give effect to the transfer,
Yes,
the transferor's right to join possession
yes.
or other common or part enjoyment of the property and to enforce a partition of the same, but subject to the condition and liabilities affecting at the date of the transfer, the share of interest so transfer.
So absolutely that is not there. It's a right. And so the person transferred would have a right to get it partitioned.
Yes.
Then only.
Now, please tell us, for a lease of 20 years, does the leaseholder get a right to have a partition? It's a lease.
It's a lease.
Can a leaseholder have a right of partition? That's why I said from third line onwards, I'm more interested there.
And in fact, the judgment which was shown by him, my lord, he also helped me, my lord, because until and his partition, it cannot be transferred. All the judgment says, my lord.
No, it can be sent, but the man is,
Yes, my
he has to
lord.
get it partitioned.
My lord.
So the difficulty is that a leaseholder will not have a right to partition. The
My lord, yes, as soon as
right
you have
to
given
partition,
this, yes.
partition goes with the
Co-owner.
ownership.
Ownership. So as soon as you give lease, my lord, that has gone.
You have four friends here sitting in the same line. Four can have a joint ownership of land. You can have a, if you're a owner, you can have a right of partition. But if you lease out to
Then that has gone.
your sister sitting behind,
Then it will be.
can she come and say that, no, I want partition?
Cannot.
If you succeed in that answer to that question, you succeed in this writ appeal. Because they're not a single word in this impugned judgment will be liable to be interfered with. You are not an eligible tenderer. And there's another difficulty. Let us accept everything which you are saying. In the original entry in that Jamabandi, which you showed earlier, there is a description of land measuring 1 kattha 15 lechas.
Yes.
In the subsequent Jamabandi which you are showing of 2016, the land is 1 kattha 6 lechas.
Yes.
So where is 9 lechas gone?
9 lesser, my lord. My instruction is that, my lord.
No, we can't go by instructions. The reason is very simple. In that second Jamabandi which you are showing, there is a reference to the order of the circle officer in partition suit.
Yes.
Their original order itself you have not disclosed. So we don't know what has happened. This 6 lechas is where we don't know. And therefore, where is this, where is this 1 kattha 6 lechas land? That also we don't know. 9 plus 6, 9 lechas is uncertain. If 9 lechas is uncertain, your 1 kattha 6 lecha is also uncertain. We don't have a description of north, south, east, west. And then there is another thing. That's why we asked whether you have given the status of the drawing of the land, because it will have some north, south, east, west. In the first Jamabandi, which you have disclosed, it's an agricultural land.
Yes. It is.
Saritoli.
Agricultural cannot be converted. It has to be converted to a commercial land, my lord. It cannot be. So I'll do the certificate annex, my lord.
My lord, my respectful submission, my lord, that condition
No,
up
no,
to the
we are not on
respondent
that.
authority, my lord.
No, no, that is not even, that we have not even suggested that.
Right.
Now you see in a Saritoli land, which would be north, south, east, west, we don't know. And in your lease deed, you have given a description of land. In your lease deed, you have given a description of land. You come to, please, come to page 75. Plot of land measuring 4 into 6 meter. At so and so, north is owner, south is Suniti Deori, east is road, west is owner. Correct. Now, where are the other co-owners gone?
He team partition করিয়ে দিয়েছেন।
Some boundary they must touch.
Yes.
So these 9 lectures, owner of 9 lectures are where? So from the documents on record, we are not getting a picture of your land. And definitely, Mr. Bhattacharya is there. He would not like to give you the ownership where the title is not clean. Page 120. Page 120. Seeing the circle of the land, a piece of Basti land. I am given permission to use land to be used for land is for agriculture and Basti use. That is rural and number 1. John doesn't say so. But then there's something wrong. Something very wrong. 120, Mr. Bhattacharya is showing. Please come to this affidavit that is at page, additional affidavit at page 136. You got that? Jamani, in the affidavit filed by the appellant. Have this? No, read that Jamani. this annexure H, this, what do you call this? Landscape paper.
My lord. Yes, yes,
You're reading that landscape paper?
my lord.
Only, not. This one. This is an English translation. Correct.
My lord.
Now, class of land is vacant. See, column 6. Correct.
My lord.
Turn to next page. In Assamese, it is written Kudong Bari. Notes of argument. What are the other judgments you are relying on, Mr. Saikia?
My lord. I have relied on 7 number of judgments, my lord.
These are on what point? You not mentioned for what point these citations are given.
Relevant para were mentioned, my lord.
No, para is okay,
Right.
but this
Yeah.
judgment is on what point? You must also understand that,
Yes, ma'am.
because we have this,
Yes, yes.
what you call,
I got.
AR manual, I can cite 1,000 judgments.
Your laptop is everything, my lord. Everything is there, I know. Each and every point in the app can be pasted.
By the end of the day, you tell us what is the point involved, otherwise we'll dictate in the order that the cases were cited without telling us on what point, because we can't find these judgments and then read the context and then find out what you are trying to say. Correct? Yes. Anything more you have to say, Mr. Saikia?
Nothing,
In a
my
piece of
lord,
paper, you write on what point you are citing these cases. Otherwise,
yes, my lord, I will,
otherwise none of the cases will examine.
yes, my lord, I will produce, my lord, today itself, my lord.
Yes.
I can mention right now, my lord.
Tell us.
My lord, AR 1950 PFC High Court is, my lord, as I have mentioned, my lord, if a co-swearer is in exclusive possession of any portion of land, then my lord, not exceeding his land, he can.
Yes.
Here 1966 JK, my lord. No prejudice is caused to the other co-sharer by transferor insofar as the vendor get those rights which will the vendor himself possess.
Correct, but how does it help you?
Next, my lord, AR 1972, my lord.
Yes, how does it help you?
If, my lord, I am in possession, my lord, of a
That
particular
position
plot
itself
of
is
land, my lord.
questionable. We have spent 5 minutes time before recess to tell you how position are determined.
And number 4 is, my lord, 1991 SCC 3273, my lord. It is essential condition of eligibility, whether it is ancillary or subsidiary, my lord. That is Poddar Steel Corporation, that judgment, my lord.
No, that is, you see, you are referring to first case you cited was Pepsu.
Yes, my lord.
Second is 1966 JK 39.
Yes,
What
my
is that for?
Yes, yes. It is, my lord, other co-owner is not prejudiced if one is transferred, my lord.
This is whose case that the other, it is whose case that the other co-owners are objecting to it. Nobody's case.
Nobody's case, my lord.
Then
Then, my lord, my contention is that I can transfer, my lord, my share, my lord.
yes. And third one is
The third one is, my lord,
JK 7.
yes, my lord,
What is that?
a co-sharer who is in actual possession or constructive possession, at least of a small portion of joint holding property, my lord, he can transfer it, my lord.
Okay.
Number 4, my lord, it is essential condition of eligibility criteria, my lord, whether ancillary or subsidiary.
Oh, we have traveled a long way from 1991 till 2022. What are essential conditions, what are not? Now the Supreme Court has interpreted that it is for the employer to judge. Court should forbear from doing it. What is an essential condition? Now the court cannot determine what is an essential condition, what is not. And how do you interpret that the requirement of the bid document that you must be the owner of the land can be interpreted to mean that the co-sharer has a right to sell, right to transfer, and the transferor becomes owner of the land by way of a lease deed. according to you, there is any difference between owner and the lessor? It is owner, right? Mr. Bhattakur? Owner. Applicant must be a owner
Applicant must be owner, man, he must be registered, lease the place.
or registered lease deed.
Which should be valid for 15 years.
Should be valid for 20 years, 15 years.
15. And if there is co-share, madam, they have to submit the.
Affidavit.
affidavit.
Co-sharers must give their affidavit.
Yes, madam.
No affidavit.
Huh?
Here in this case, no affidavit. He
Okay, where is
simply-
that requirement? Nobody told us. Where is
Yes,
that
my lord. That
requirement?
requirement page, my lord, your lordship kindly see, my lord.
Page 40.
Page 40, 41. Page 40. Page 40, my lord.
I cannot tell anything of,
Just a moment.
Yes. Method আছে না? method করেছে তো?
68.
Page 40, my lord. Last but one para, my lord. Forty.
68.
Okay.
And that is actually, there is a format also, page 68, my lord. How it can be filled up, my lord. Page 68, my lord. Right hand column, my lord, last but one. Page 68. In case land is in the name of members of the family unit, consent from the family member in form of notarized affidavit, annexure 2, in required to be attached here with the application. So there is a format, my lord, how it can be given. In the bid document, there is an annexure. So that affidavit not done.
Okay. The other judgment? Cochin International, why you are citing?
Yes, my lord, it is, if it is a larger interest, my lord, it is, if it is public interest, not a private interest, my lord, then my lord, some sort of irregularities may be.
Mr. Saikia, we have a query in that third citation you gave us.
My lord.
You are being offered LPG distributorship,
Yes,
correct? So the place where will you run it? That means the space, the house or the shop, whatever you say, according to you, it is an ancillary requirement.
yes, my lord.
Okay. It is not an essential requirement according to you.
Yes, my lord.
Okay. So what according to you is an essential requirement then?
My lord, my contention is that, my lord, if any discrepancy, irregularities, my lord, and my lord, may I draw your lordship's kind attention by page 51, my lord. Page 51, my lord.
What is it? Tell us. Tell us what is page 51. Tell us what is there.
In case deficiencies are found in the application, a letter would be sent to the applicant to rectify the deficiencies within a specified period of time. That is up to the authority.
No,
That is
we are
my
on that.
contention, my lord.
We are not on filling up of the form right now.
Right.
What is deficiency? We are not saying. Filling up of deficiencies, supplying the document, those are different interpretations. We are not
Right.
on that. According to you, for an LPG distributorship, land is an ancillary requirement. Okay. Now, fourth, Cochin International, fifth case.
My lord, it is, if it is larger public interest, my lord, involved, then my lord, BSN Joshi is also tender condition, my lord, which are to be strictly dealt with.
I hope before citing this Cochin, you have read this paragraph 7. You have cited para 7. Have you read that before citing?
I have to be prepared,
you
my
have
lord.
not.
Today, my lord,
So we'll tell you.
I may not be.
We'll tell you what is there in paragraph 7. Why we remember this paragraph 7. Paragraph 7 says, the award of a contract, whether it is by private party or by a public body or a state, is essentially a commercial transaction. In arriving at a commercial decision, considerations which are paramount are commercial considerations. The state can choose its own method to arrive at a decision. This is something we have been using time and again. Okay, next citation after Cochin is Jagdish Mandal.
Yes, my lord.
Now please tell us, how does this help you?
My lord, matter relate to the government contract, my lord. My lord,
Yes.
it is related to the judicial review, my lord.
Incidentally, this is also something we both of us almost well acquainted. My brother is more what you call, he'll remember it more than me. Because here it says that court should examine whether the decision is lawful and not whether it is sound. This para 22 which you are relying on. And then it's Central Coalfield.
It is also, my lord, essential condition, ancillary or subsidiary, my lord. Same, my lord, same as for my. Poddar Steel Corporation and my lord, Central Coalfield, my lord. It's more or less similar, my lord.
Here also, I think you have read this paragraph before citing. You see, we'll read paragraph 47, one part of it, one line of it. The result of this discussion is that the issue of the acceptance or rejection of the bid of a bidder should be looked not only from the point of view of this unsuccessful party, but also from the point of view of the employer. As held in Ramana Dayaram Shetty, the terms of NIT cannot be ignored as being redundant or superfluous.
জগদীশ ভাইয়ের সব ডিসকাস করা আছে CCL CCL
There's a one, there's one of 43 minutes. In
Huh?
case one of the, if it is an error of accessor,
Page para 43.
43. And the 43. So this one will be discussed.
CCL টা আনিছো না?
No, this is different because after this, in another decision, the because after
Takamura, sir.
sometime here, there was a amendment brought, or subsequent to this, there's an amendment brought in the Specific Relief Act.
Yes.
A provision was brought in, 26, 23A or 21A was brought in. That public projects should not, no, there should be no injunction on the public projects.
NG
NG projects.
NG protection and no.
নলগিন্দা আছে না ঘরে নলগিন্দা একটা ঘরে নলগিন্দা
If there is a statement that you should be undertaking.
Okay. Yes, Mr. Manta, anything more you want to add?
No, my lord, I just pointed out, my lord, that query which is made, my lord. He says that I am the owner of the that plot of land that is already discussed by the honorable single judge by para 16, my lord. May I read it, my lord?
Para 16,
My lord.
page number?
Page number 98, my lord. Page number 98, para 16. Registered lease deed. It goes
Just a moment. Yes,
a registered lease deed, it goes without saying it, para 16, my lord.
yes, yes.
It is to be executed by a person who has ownership of the title of the property. Owner of a plot of land and co-owner of a plot of land are entirely two different things having different legal contraction in this mission. So he is section 44, my lord. Owner and co-owner complete two different dimensions. So co-owner of a plot of land does not have any ownership of a definite area within the plot of land, and as such, they cannot execute a lease deed in respect of a specific area. In the lease deed, a specifically bounded by the land as was given in possession in the leasehold as the absolute owner, while it has not. Therefore, he said registered lease deed cannot satisfy the requirement of the owing a plot of land, terms and clarification and notifying at notice above. As such, the application of the Respondent 5 was effective in respect of this whole element. So, condition that it is a ownership of the plot of land, which is, my lord, one of the essential conditions, my lord. Mr. Day submitted an inquiry was made as so and so, 18-year lordship. Subsequently, mutation of the name of the burglary over the plot of land is no consequence. The validity of the land, every tender is to be judged on the date of submission of tender. In instant case, the last date of submission tender is 31/10/2013. The leaser of the Respondent 5 was not absolute owner of the land in that question. So, my lord, there is nothing to interfere. Everything will be discussed every area. Now, my lord, the only question is that, my lord, it's a drop lot. Now, there is a order for redraw. There is a provision in the my lord, NIT also that when such situation arise, my lord, it has to be, my lord, redraw. Page 53, my lord.
53.
53.
Yes.
Condition for redraw. Page 53, my lord, clause 12. Already there is a direction to redraw.
Yes.
So, so already there is a direction from the Honorable Court to for withdraw in the last part of the judgment is clearly mentioned that the respondent number 1 to 4 are directed to conduct a withdraw of lot among the eligible tenderer. So that was been stayed here. That's why, my lord, that was not been done till today. So my submission before your lordship, my lord, that was the essential condition which was not fulfilled, my lord. His actually tender should have, my lord, rejected, my lord. The Nanath single judge judgment is, my lord, nothing to interfere. It's very soundly, my lord, possible.
Yes, Mr. Bhattakur.
And my lord, just a minute, my lord, the judgment which was, my lord, regarding possession that was here, my lord, there's a judgment, lots of judgment. Now all the judgment says, my lord, that is, my lord, one is, my lord, Ramdas. Ramdas. These two judgment, my lord, I'm just entering there. No, maybe 17 point, I think 17. 17. This judgment, my lord, para 17, my lord. In view of the aforesaid position, there could be no dispute with regard to the fact that individuals,
Which paragraph?
para 17, my lord,
Just a moment.
my lord, Ramdas.
Just a moment. Yes.
Para 17, my lord. In view of the aforesaid position, there would be no dispute with regard to the fact that an individual share of undivided share or co-share may be a subject matter of sale, but possession cannot be handed over to the vendor unless the property is partitioned by meet and
Just a moment.
Strongly.
It was. Okay. Huh?
Yes, I'm sorry. Yes.
My lord, that para 17, my lord.
Yes, in view of the.
My lord. In view of the aforesaid position, there would be no dispute with regard to fact and individual share of the co-share of the by subject matter of sale, but possession cannot be handed over to the vendee unless the property is partitioned by means and amicably and for mutual consent by a decree of the court. So a similar line, my lord, the Gujarat Unis case, my lord, that is also cited by him also. That is in fact helped me para 11, my lord.
Which one? Which case?
Another one, my lord, that is 2009-13, 2009-10 SCC 654. In different, my lord, report, my lord, sometimes paras are different. That's why I'm giving the judgment, my lord. Para 11 here also. So that was also his also cited, my lord, but that is helped me, my lord. Because until and unless partition, my lord, he cannot claim that it is my share and it cannot be transferred, my lord.
Yes.
So these are the arguments, because I countering there. Correct. Even our High Court division based judgment measure. No. You cannot take second case then. That is the same. Yeah. There are 23. My lord, another judgment, my lord, our High Court. Hmm.
On the last date of submission, it was the last date of submission. It was
It is best. Yeah, my lord, one WPC 4404 of 2021. That was the judgment of our High Court.
WPC,
WPC 4404 2021. In para 23, my lord, the stand of the my lord respondent, they cannot change their stand now, my lord. That my lord, qualification has to be on the date of submission of the para 23, my lord. In para 23, in the instant case, there is no doubt,
let my brother go to it.
my lord. So that is their stand, and their stand that by the essential qualification that has to be on the date of last date of application. That is their stand of the my lord respondent authority, my lord. In other cases, in similar situation, my lord.
Yes, please come to it. 23.
23, my lord.
Huh.
In the instant case, there is no doubt that the registration of the lease deed was done much after the date of submission of the application. That is on 25/6/2018. It is to be a settled position of that crucial debt for possession of the required qualification for the consideration of the public allotment of process is the last date of submission of the application and not thereafter. Is that a judgment here cited, my lord? That is. So they stand in other cases, my lord, this one.
So you want to stop Mr. Bhattakur from making any?
No, my lord, he can take the stage. That's why I'm talking.
Yes, Mr.
Deputy
Bhattakur. Are you changing the stand?
No, madam.
He can.
No.
Yes, sir, applying 43, madam, 43.
Then CCL 43. Yes.
Our, now I cannot develop by case, madam. Our extended page number 107, madam, that is our affidavit, madam. The expedition, madam. Before, madam, kindly see page 77A, madam. What is in the plain
77A.
A, madam? These are suit filed by the madam, plaintiff, madam.
77A, yes.
ma'am. Is a plain, madam. Para 3, madam.
No, plaint is withdrawn. So once it is withdrawn, nothing
Yes,
remains.
Madam, para 3, madam, last line, madam.
And where is the order of withdrawal?
It was not annexed, madam. We have stated in our affidavit, madam. We have stated. in
Where
our
is that?
affidavit, madam. 108,
Is
madam.
103, madam.
Hmm?
103 of
103, madam.
from middle portion, my lord. There is no dispute with regard to the
Just
title
a
and
moment.
possession.
103, yes. Just a moment. In the beginning.
16 line, my lord.
There is no dispute, yes. Disposed of by order dated 4/6/2015 on compromise.
And the para start from 102, my lord.
Then again, Mr. Sekhar, there is something wrong. If you are accepting this, then you are damaging your case. You had mutation in respect of 1 kata 15 acres of land. Correct. Now in this statement here, it is given that in terms of compromise, separate patta is to be issued in favor of plaintiff to the extent of 2 kata 4 acres. Now land is growing old, or what you call, it's what you call enlarging. That is one. Then in your mutation order of 2016,
1 kata 6.
now 1 kata
6,
9 acres,
yes.
1 kata 6 acres, yes. That means you are not acting as per the compromise. That means out of 4 people in compromise, 3 people lose their share. And then again,
But there are
if-
2 ducks, my lord. 1074, 1072, my lord. All total, my lord, 3 become, my lord.
no, we don't know.
Yes, sir.
Your document says
But it is in a plain, my lord.
we don't know about the plain. We are now examining the Jamabandi. And we are comparing it. It is the land in the Jamabandi given to you.
Yes.
Not land in the plaint.
Yes.
Correct. Now in the Jamabandi, if the sharer is, there are 4 sharers for 1 kata 15 acres of land.
Yes.
And one gets 2 kata 4 acres. Now where is the share of 3 people? And if there is a agreement to extinguish the share of 3 people, then it must be compulsory registered.
Yes.
Yes.
By compromise, it can't be extinguished. Any document which tends to create extinguished title having value of more than ₹100
It has to be registered.
is required to be compulsory registered under section 17.
Registration.
So in your affidavit in opposition, you did everything to help him.
Because that's why I'm saying, man, I cannot develop my case now.
Then it is okay. We stop it here. Brother, we stop it here.
This one. It's better for me, my lord.
And Mr. J.S. Saikyal and counsel for the appellant also heard. Mr. P.J. Mahato and senior counsel assisted by Mr. R. Chakravarti and counsel for respondent number one, as well as Mr. S. Bhattakur and counsel for respondent numbers 2 to 5. Let's go. By filing this intra-court appeal, comma, the appellant, who was the respondent number 5 in WPC 3473 of 2016, has assailed the order dated 14/5/2018, passed by the learned single judge in the said writ petition. By the said impugned judgment and order, the learned single judge accepted the challenge to the allotment of LPG distributorship to the appellant by holding that the tender of the appellant, being respondent number 5 in the writ petition, bracket, being defective, and it was held that her selection in the draw lot as a successful candidate cannot entitle her to award of the LPG distributorship. Full stop. Consequently, the respondent numbers 1 to 4 were directed to conduct a re-draw of lot among the eligible tenderers, including the respondent number 1 herein. Next further. In brief, the case of the appellant is that the appellant, the respondent number 1, and some other applicants had participated in a tender process of Bharat Petroleum Corporation Limited, within bracket BPCL for short, bracket close, pursuant to an advertisement dated 30/9/2014 for appointment of LPG distributor, amongst others, in a location at Jagi Road in the district of Morigaon, which was reserved for scheduled tribe category applicants. Full stop. The last date of submission of tender was 31/10/2014, and the selection was envisaged by way of draw of lots. Full stop.
But the last date was 31/10/2013, my lord. It's not 14.
In the judgment, it is written
Here it is
14.
wrong, my lord. That is
Wrong.
wrong.
It is 13. 31/10/2013. It should be, not 14. Huh? So in the draw of lot, the appellant was declared to be successful. Full stop. The selection of the appellant was assailed, amongst others, on the ground that her tender was in violation of clause 6.1 within bracket Roman 8 of the guidelines, which requires that only an owner of the land should apply for the owner of the land, which includes a registered lease deed holder, to apply for LPG distributorship. Full stop. The next para, the learned single judge accepted the contention of the respondent number 1, comma, who had successfully demonstrated that the appellant was not the owner of the land and not the absolute owner of the land, comma, which is based on entries made in the Jamabandi for the said land, which indicates that pursuant to the order passed by the circle officer dated 24/2/2009, passed in mutation case number 66/08-09, comma, showing that on inheritance, a land measuring 1 katha, 15 desha, land was mutated in the name of four persons, including the lessor of the lease agreement, a registered lease agreement dated 29/10/2013. No, where is that sale deed? I'm missing it out. Where is that sale deed? Lease deed?
72.
Huh?
72.
72. Lease, registered deed 29/10/2013. Comma, namely, comma, Sri Bogiram, Bagiram, Bogiram Deori, Dewri. Next para. It was further held by the learned single judge that the appellant has not brought on record any document to demonstrate that on the date of submission of tender, comma, Bogiram Deori was the owner of the plot of land measuring 4x6 meter, which he had leased out to the appellant by agreement dated 29/10/2013. And it was further held that the Jamabandi of the land in question goes to show, but this is not required. We have already said that. Full stop. Accordingly, comma, it was held that the claim of Bogiram Deori in the lease deed that he is the absolute owner of the land, which was leased out, was not true as on the date of execution of the lease agreement. And it was held that he was not the only absolute owner of the said plot of land, but was a co-owner along with some others. Full stop. Not full stop. Notwithstanding that the name of Bogiram Deori was mutated on 6/12/2016, comma, the learned single judge had held. Now, it was held in the writ petition that the subsequent mutation of the name of Bogiram Deori over a plot of land was of no consequence, as the validity of the tender is required to be judged on the date of submission of tender. And in this case, the last date of submission of tender was 31/10/2013, when the lessor was not the absolute owner of the land in question. Full stop. Resultantly, comma, it was held that the lease, the tender was defective. In tender of the appellant was defective. And accordingly, direction was issued for conducting a redraw of lots from amongst the eligible tenderers. Next part. The learned counsel for the appellant has stressfully submitted that as a co-owner, Bogiram Deori had right to transfer his share of land, being in exclusive possession of the said land, to the appellant. And in support of the said contention, reliance has been placed on the case of Chanaram Singh, Chanam Singh, SINGH, versus Santa, SANTA Singh, AIR 1950, PEPSU, PEPSU, PEPSU 5, Musammat MST, full stop, Rathi, RATHI, versus Wali, WALI, next word Ganai, GANAI, and others, AR 1966, JNK 39, Rahim Sheikh, RHIM, Rahim, SHEIKH, versus Samad, SAMAD, Sheikh, AR 1972, GNK 7, full stop. In respect of the said decisions, there is no dispute or quarrel with the proposition laid down in the said cases. Full stop. However, the said cases do not help the appellant in any manner, because the appellant has not been able to demonstrate that on the date when the tender was submitted and opened, the lessor was the absolute owner of the land in question, nor it could be demonstrated that he was in exclusive possession of the said land. Next para. On examination of the documents which are appended to this writ appeal and affidavits filed thereto, we note that the initial entry in the Jamabandi relates to mutation of name of 4 persons in respect of 1 katha, 15 lechas of land. Full stop. The subsequent mutation in the name of the appellate discloses that upon partition, the said entry was made and 1 katha 6 lecha land was mutated exclusively in the name of the vendor of the, lesser of the agreement. Full stop. However, in the affidavit in opposition filed by the respondent numbers 1 to 4, it appears that land measuring 2 katha 4 lechas was held to fall in the share of the vendor, lesser of the petitioner, which means there is an excess land compromised in favor of the lessor, whereas the mutation is only in respect of 1 katha 6 lechas of land. Full stop. Therefore, even from the documents appended to the to this writ appeal, as well as affidavits filed therein, the exclusive possession of the lesser cannot be prima facie determined. Full stop. None of these documents contain the actual dimension of the land in meters, nor it discloses the actual location. Full stop. Therefore, as stated above, the said 3 cases cited by the learned counsel for the petitioner does not help the appellant in any manner. Next paragraph. The learned counsel for the appellant has cited the case of Poddar PODDAR, Poddar Steel Corporation versus Ganesh Engineering Works and others, within bracket 1991, bracket close 3 SCC 273, to project that while essential conditions of the tender cannot be deviated from, but ancillary or subsidiary conditions may not be insisted upon. Full stop. We are unable to accept the said contention because if the respondent numbers 1 to 4, 2 to 5 are offering distributorship of LPG, it cannot be accepted that the situs, SITUS, situs of such distributorship would be an ancillary or subsidiary issue. Full stop. The cases of Cochin International Airport Limited versus Kambata, CAMBATTA, Aviation Limited and others, comma, within bracket 2000, bracket close 2 SCC 617. Comma, cited by the appellant, by the learned counsel for the appellant. Allows the body which is awarding contract to choose its own method and arrive at a decision. And it is further held therein that the state, comma, its corporations and instrumentalities are bound to adhere to the norms, comma, standards and procedures laid down by them and cannot depart from them arbitrarily. Stop. The set principles are reiterated and followed in the case of Jagdish Mandal versus State of Orissa within bracket, comma, within bracket 2007, like 14 SCC 517, and Central Coalfield Limited versus SLL-SML Limited, comma, within bracket 2016, bracket was 8 SCC 622, both cited by the learned counsel for the appellant. Full stop. Next paragraph, therefore, comma, it is not open to the court to make an interpretation that the land on which the LPG distributorship is to be functioning is not an essential criteria. Full stop. It has been demonstrated by the learned counsel for the respondent numbers 2 to 5 that as well as the learned senior counsel for respondent number 1, that as per the terms and conditions of the tender, comma, inverted commas, own, OWN, own is defined to mean having ownership, title of the property or registered lease agreement for minimum 15 years in the name of the applicant, oblique family member, as defined in multiple distributorship norm or eligibility criteria. And it is further provided that in case of ownership, oblique co-ownership by family members, comma, as given above, comma, consent in the form of notarized affidavit from the family members will be required. Full stop. The said criteria is also reflected in in column 9, in row number 9 of the general instructions to the candidates applying for LPG distributorship, which forms a part of the tender tender document. Full stop. There's next paragraph. There's nothing on record to show that the said condition at row number 9 of the general instructions was of no objection from the family members in form of notarized affidavit was attached to the application of the appellant. Full stop. Ex specie, comma, the land is muted in the name of 4 persons. And therefore, the non-availability of the affidavit of the other co-owners appears to be a good ground for the learned single judge to interfere with the into the selection of the appellant as a successful bidder. Next paragraph. Next paragraph. The learned senior counsel for the respondent number 1 has placed reliance on the case of Gajara, Gajara. Next word, Vishnu, Vishnu. Third word, Gosavi, Gosavi versus Prakash, Nana, Nashed, Nana Sahed. One word, Nashed. Kamble, Kamble, and others, as well as no, sorry, citation will be
2009 10 SSC 654 Miller.
2009 10 SCC 654, as well as Ramdas versus Sitabai and others, 2009 7 SCC 444. Wherein the Supreme Court of India has held to the effect that while a co-partner of a undivided, whereas undivided share of a co-partner can be subject matter of sale oblique transfer, but possession cannot be handed over to the vendee unless property is partitioned in metes and bounds. Full stop. Therefore, the on facts and in appreciation of law, we are unable to find any fault or perversity in the judgment impugned in this appeal, intra-court appeal. Next paragraph. we take note of the decision of this court in the case of state of Tripura versus Ramendra, R-A-M-E-N-D-R-A, Ramendranath De, within packet, 2000, within packet 3, packet was GLT 214, wherein it was held that in intra-court appeal, judgment of the learned single judge should not be set aside or quashed. Sorry, should be set aside and quashed only when there is a patent error on the face of the record, or when the judgment is against the established or well settled principle of law. Full stop. It is also a strike law that even when two reasonable and logical views are possible, the view adopted by the learned single judge should normally be allowed to prevail. Full stop. If one wants an authority on the point, the case of the decision of this court in the case of Starline Agency versus Navajit Das, 2011, within packet 1, packet was GLT 710, may be referred to. Full stop. Again, in the case of Assam State Electricity Board versus Sri Surya, S-U-R-Y-A, Kanta, K-A-N-T-A, Roy, within bracket 1994, bracket close 1 GL-R 383, this court has held that the appellate court would not interfere with the discretion of the court of first instance and substitute its own discretion, except when the decision has been shown to have been exercised arbitrarily or capriciously or perversity, or where the court has ignored the settled principles of law. Full stop. Next, in the present case in hand, the appellant has not been able to demonstrate that the impugned judgment suffers from any of the conditions referred in the foregoing paragraphs. Next, accordingly, this intra-court appeal fails and the same is dismissed. Next, the interim order passed on. What is the date of interim order? Date of interim order.
23/7.
23/7/2018. Staying the operation of the impugned order dated 14/5/2018 stands vacated.
Regarding read royal, time frame may be given.
Pardon me?
Regarding read royal, there is a direction from the honorable court to read royal within last line of the earlier judgment, So, again, you lordship giving a for read royal, time limit will be given.
We will not say that. Next, full stop. Resultantly, there would be no impediment for the concerned authorities to comply with the directions contained in the order of the learned single judge.
Deeply.
Anything I have left out?
No, that's all, I think. It is good. Yes. Deeply.
IA is pending.
Oh, Miller, yes, I is pending for status quo.
I think-
I asked status quo.
What is this IA for?
Stay vacating.
Miller,
That
break
was
for
a-
status quo.
Oh, acha.
It was not.
I, in view of
Yeah, I disputed.
disposal of the conducted writ petition, this IA stands closed.
Deeply.
Machunga.
Deeply.
Item 3 for hearing.
Maybe lordship. Kindly better we fix on next week, lordship. My senior has done
Okay, use for 2 weeks, in fact,
2 weeks. Oh,
because the other respondents are also not there.
although it is not there.
Okay, then we are not saying anything, roll over. We are otherwise also rising at 3:30. Okay, all of the matters will be adjourned because we have to rise at 3:30. There's a single bench.
Yes, lordship. After 2 weeks, lordship. After 2 weeks. it will be done.
They will list it. It will be rolled over.
Much obliged.
And they have accepted it also. The whether that would mean that
there's a
my
letter
lord's view
which
was that it is satisfied. That's all. But it need not be a lengthy affidavit for that, only on that short point. They acknowledge that receipt of that letter. But
But
how did it?
I want to submit a.
Very well.
Respond to the
Very
entire
well.
review petition, your lordship. So 2 weeks time, your lordship made.
In the meantime, nothing may happen.
The one-man committee is there.
One-man committee is there.
Will continue, your lordship.
Both sides are represented. Mr. V. Rajput on a standing counsel for the Corporation Department. Grace Foran is granted 2 weeks time to obtain instructions and to file affidavit if so advised. Give a date after 2 weeks. Single bench matter.
Obliged.
Item 1.
Yes.
Please, both the sides have submitted written submission.
And what you are saying about the judgment that unless a CFSL report is annexed, the charge sheet is incomplete?
Lordship, the issue was dealt by this honorable court. In two judgment, Lordship also dealt with that. Lordship, the ultimately the matter went to Supreme Court. Supreme Court says that the matter is referred to full to decide to the larger bench. But in the meantime, no interim bail was granted. Lordship, in one of the judgment passed by your Lordship. And Lordship, interestingly, this point was read by the first time. Earlier, bail was rejected. of
No,
this
that's
petition.
okay. It's a point of law.
No, Lordship, the purpose of FSL report is that whether it is evidential value or not, but subsequently it can be produced also. But in this case, Lordship subsequently produced. At the time of filing charge sheet, but at the time of seizure, the seized drug was tested with a detectant kit, and the result was found to be positive. On that basis, Lordship, we proceeded and the sample was sent to the FSL for report. At the time of filing the report, that report was not there, but subsequently it was filed.
You are saying that this order of 25 is referred to a larger bench of Supreme Court?
No, Lordship, another issue from Delhi High Court that has been.
No, yes, it is a fact, my lord. It has been referred, but Supreme Court says until that reference is answered, the law which is prevailing on that.
I'm
day
just
will-
trying to understand because he has placed one of my orders. I'm just trying to understand. Because
No, my lord, what I was trying to say, even if an order is referred, Supreme Court has said, the reference will be answered in due course, that's okay. But till such time, the law which is referred, that will prevail. And Lordships wanted to have a look at the Supreme Court judgment that I have brought.
yes,
Photo given, right? Let us set this up.
Yes.
My lord, we have given a set.
yes.
Yes. These are the small factual points, my lord. If your lordship would kindly come to page 4. The main relief sought by the petitioner in this petition is that they are entitled to bail in default on account of the fact that investing agency has failed to file police report under 173(2) of the CRPC within the stipulated period of 180 days. Although it is not disputed that the report was filed within the stipulated period, the petitioners contend that the said report was incomplete as it was not accompanied by report of the chemical examiner. Third, learned counsel for the parties and carefully peruse the materials on record. Taking into consideration the fact that the petitioners have suffered incarceration for a period of 2 years and 11 months, we are inclined to grant interim bail to them for the period of 3 months from today, subject to the terms and conditions to be imposed by the trial court. The petitioners are accordingly directed to be enlarged on interim bail for a period of 3 months from today. So, my lord, an FSL report, and next para, my lord, the relief sought by the petitioner in this petition is that he is entitled for default bail as the complete and final challan has not been filed within 180 days and the final report was not accompanied with FSL report. Heard the learned counsel for the parties and carefully perused, taking into consideration the fact, the same thing, Miller, in both the cases, on that count, interim bail was granted. And secondly, my lord, in this case, if your lordship would kindly come to page number 16, para 31, it is an admitted position, my lord. The charge sheet was without the accompanying, my lord, chemical examination report, para 31. That on 22/12/22, total 25 original marked as P so-and-so to so-and-so, MS, HS so-and-so, seal so-and-so, were exited from the NCB godown, sent to CFSL, Urput Kamru. For chemical, like a reminder was sent to this CFL so-and-so for the same and reply is awaited. So admittedly, my lord, it was without FSL report. And my lord, the actual report, lordship will find at page number 2, which was given subsequently on 14/7/23.
Page number,
14/7.
page number.
2, my lord. CFSL report of seizure contraband which was seized in connection with so-and-so has been received from Central Forensic Laboratory with positive test for seized contraband. So it was on 14/7, subsequent. Well, it is something like 167 my lord. It's a question of default. It's a legal fiction. So once there is a
Page 2 of which comparison?
this same compilation, sir. The one which I have given. Dated 14/7/23.
Oh, acha. Okay.
It was sent only on 14/7.
Yes.
So beyond 180 days. So therefore, my lord, you are entitled. My lord, recently Calcutta High Court has also taken the same view, my lord, that if the challan is not accompanied by FSL report, it will be construed as an, my lord, incomplete report and the accused is entitled to default bail. My lord, this is the Calcutta High Court's view, my lord.
That's it.
It's a division bench judgment of the Calcutta High Court, my lord. Para 14.
In view of the undisputed fact that in the present case, the charge sheet, although filed within the period of 180 days, was not accompanied by FSL report, and that FSL report was filed as a part of a supplementary charge sheet filed beyond 180 days from the date of arrest of the petitioner, and after he applied for statutory bail. We have to hold that upon expiry of 180 days, the petitioner became entitled to statutory default bail, and learned trial court erred in not extending that privilege to the petitioner. Division bench judgment of Honorable Calcutta High Court. My lord, in an NDPS case, without the chemical examiner's report, it will be, in fact, in one of the case, my lord, when the charge sheet was not accepted. In an appropriate case, or in every case, it may not be fatal, but in an NDPS case,
The only consideration is the amount of damage it is doing to the society.
that's correct, my lord. That is absolutely correct.
Means,
I don't know what
I-
has happened in this country, my lord. We are arguing that's a
No,
different issue.
but I am first concerned with the state.
Correct, correct.
Because
Absolutely.
the amount of drugs coming in today is not entered my home, but we can't say for tomorrow.
Oh, yes. And conscious people, my lord, they are indulging. The news which we get around, even the conscious people are resorting
Yes.
with good family background and all. Very unfortunate.
But see, recently a report has been prepared by the NCB. The data which were revealed, 80% in the hostels, drugs, the students are consuming drugs. And there was a note that few practicing advocate, they are coming to the court after consuming drugs. They have disclosed the name also.
No,
no?
we see, we
NCB.
can't generalize,
Yes.
unless we come to a specific incident. But the fact is that that is the larger picture.
Yes, this is the.
There's no doubt about it. Absolutely.
Okay. Uh, The submissions of Mr. K. N. Chaudhary and Senior Counsel is concluded, and he has also submitted a written note along with the case citations. Full stop. The submissions of Mr. S.C. Kyal and Standing Counsel for the NCB is also concluded, and he has also submitted a written submission along with case citations.
But see, one judgment kept remain. Recently, Supreme Court dealt with this issue also. Unfortunately, I could not brought this judgment. This is an order. I'll place tomorrow. Also.
Give it to Mr.
Yes, I
Chaudhary.
will. He can
Yes.
give a copy by furnishing one to me, no problem.
Okay. Order reserved.